Welcome. Welcome to TalkTime with Sharmin. And I am your host, Sharmin Prince. Happy Sunday to you and your family. Hope you had a great week last week and you're looking forward to a great week next week. And you had a wonderful weekend. If this is your first time viewing TalkTime with Sharmin, TalkTime with Sharmin is a live Facebook show that informs, empowers, encourages, motivates, and we're live every Sunday at 6 p.m. right here, same time. Don't change that dial. Remember to invite a friend um, to the show. Today's show is focused primarily on social problems. We were supposed to have a guest from Guyana who is um, working with street homeless. I was really excited about having her, but she sent me a message earlier to say that she's taking soup for the street homeless clients and she's not sure if she will be back. So I decided to switch around. And so we would have attorney Vivian Williams. He's no stranger to Talk Time with Charmin. And he will be on at at 6:10. So in actually 6 minutes, because I promised that I will share my experience for the first 10 minutes. Please like and share. Please share with with your friends on your page. Thank you, thank you, thank you. Thank you for sharing. But yeah, um, I wanted to share some things that were on my mind. And then I thought about it and decided against it because in doing so, I may say something or some things that might offend some people. And at this point in my life, I don't need to offend anyone because people are super sensitive these days. And, thinking about what I would have said, I know we would have had a few people that are offended, and I really don't want to do that. However, I want to thank you for tuning in today. I think I saw Petal and Deadly. Yes, Deadly. Good night. Thank you. Thank you. Um, I think I saw Samantha. All of you, if you're viewing for the first time, welcome to Talk Time with Charmin. Tell your friends it for my all timers. Thank you. Thank you for your continued support. Hey, Audrey. Um, thank you guys for your continued support. We have a great, great show for you today because, domestic violence is becoming a, I want to say it's at a pandemic level in Guyana because this morning I was on the phone with someone who is on the ground in Guyana, and when she told me some experiences that she has had, she's a social advocate with domestic violence, and the level of violence against women in Guyana, and nothing is being done. It is at a pandemic level. The cruelty of our men to women. Um, vagina out. Nothing was done. The other one shaved his girlfriend, wife, or whomever had because she might be or men might be looking at her. These are, and women are afraid. Some women are afraid to come forward. Some of them are staying because, of course, the economic circumstances that they're in. So we have a lot of work to do in Guyana. There is a domestic violence march scheduled for the 29th of April in GC. And just like how, we will have Easter and now the carnival, people are planning to go all road should lead to Guyana for that march because we have women that are suffering. Can you imagine someone that you were once in love with is figuring your vagina, cutting a piece of it, shaving your head, beating you and the children? One woman was murdered, I think, in the presence of her children, but they didn't have enough evidence or something to that effect. I hope when she comes on, we can talk about that case. And those children are still with their father, live with their father because he was never charged. The young woman that was strangled, listen, we need a domestic violence court. We need a special victims unit for domestic violence. And I don't know if I included that in my petition that I submitted for Leonard Archibald. But I need your support once again because we will do the petition route this time for domestic violence. Too many of our women are dying. Too many of our men don't know how to handle the stress of life, the stressors that relationships bring, because there will be stressors and they lack the coping skills. So we want to ensure that we're helping our men to cope better and not brutalize and abuse our women. This phenomenon has gotten out of control and might need some international intervention because for the number of women that are being abused and are silent, it's a major, major problem because they don't think that if they file a complaint, anything would be done. They don't have trust in our police and they don't have trust in the judiciary system. I remember while in Guyana in the 90s, there was a domestic violence bill that was passed in Guyana. Is it being enforced? I don't think so because men are too comfortable in doing whatever they want to do to women, and it must stop. We all must come together and do what little we can do for these women and their children. And it has been proven by studies that children that are exposed to domestic violence continues the cycle in their adulthood. So either they become batterers or they become victims. So we really want to ensure that we're helping them, helping our young people, helping our women, empowering them, giving them skills so that they can begin to become independent because a lot of them are staying in the relationship because they don't have any skills, they're not qualified, and some of them, if they have skills, they're no job. So they're totally dependent on the abuser. What can we do? If the woman woman runs away from the husband or the man and goes to the family sends her right back into the abusive relationship. So there is a need for a place to hide, a place where a family, a woman and her children, or even a man and his children can run away from the abusive spouse and be safe somewhere where they can be safe. And this is a demand that we'll have to make. And my guest is here, and I'm excited because let me get my headphones. Good evening, good evening, good evening.
Good evening, Sharmin. How are you?
I am great, and how are you?
I am greater. I, I I take it that you're hearing me loud and clear.
I am hearing you loud and clear.
Well,
So, everyone, welcome. Welcome. Next to me, you will see attorney Vivian Williams. He's no stranger to this show. And I want to thank you, Attorney Williams, for being on Talk Time with Charmin and for coming tonight to lead this discussion, this important discussion about domestic violence and the plea of domestic violence and the trial of mental illness in Guyana.
well, I like the way you put it. So I am going to talk about the insanity defense. Um, the insanity defense is a very controversial defense in criminal prosecution,
Mm-hmm.
and that is across the board. There are several studies done in the United States, Canada, North America, and even in Asia. Um, and it shows that scientifically, the response to the insanity defense is almost the same in all of these jurisdictions.
Mm.
And I find it particularly interesting that not that the defense has been pleaded by uh, now a prominent defendant in Guyana, who is the military officer charged with the slaying of his partner. That case is particularly relevant because it touches on several vexing um, issues that have been at the center of the insanity defense historically and up to today. And before I get into the specifics of that particular case, I would want to do some backgrounding on the insanity defense.
Mm-hmm.
And there are a few key things that we ought to know about, or we should note from the inception about the insanity defense as we lead into what seems to be an intention to raise this defense in this particular case, and why I find this strategy to be of particular significance, relevance, and to some extent strange. Now, the first major thing about the insanity defense is public attitude towards the insanity defense. And the public attitude is largely a negative one.
Mhm.
And this is what scientific research is showing. This is not an opinion piece. They before defense attorneys decide that they would raise a particular defense, one of the things that you ought to do is to research what is the um, public perception with respect to that defense. What are the challenges that that particular defense may face? Because at the end of it all, if you go out with a particular defense, you have to look at how the jury will respond to that particular defense. And you have to take into consideration the specific crime and the specific defendant in any given case. So let's look at some general scientific facts about the insanity defense. One, there is a negative public attitude towards the insanity defense. And that is because globally, people tend to think that societies are largely punitive, and they believe that when people commit crimes, that they ought to face the penalty for their crimes.
Mhm.
And so that is a general perception that underlines public attitude towards the insanity defense. The other significant problem with the insanity defense is, or public perception, is that it is viewed generally as people or a defendant who commits a horrible crime trying to use a loophole in the law to escape punishment. And our societies across the world don't like this. So the insanity defense faces an uphill battle wherever you take it. So that's the first thing that we need to get out there and we need to understand. The other point to note about the
Mhm.
insanity defense is that there is a power relation factor that goes into public response to the insanity defense. In essence, juries tend to be more lenient and more accepting of the defense when it is raised by someone who has who is viewed in a more vulnerable position in society.
Okay.
People who occupy positions of power, authority, and influence scientifically, we're not going off of mere discussion, we're going off of research. And the important thing is that this research is research that spans various continents. That wherever you have a person who is viewed as more vulnerable, that the defense is more likely to be given a hearing. Persons, and given the general perception that people should stand the you do the crime, you must do the time,
Mhm.
people are particularly skeptical when persons who are in positions of power, position of influence, commit serious crimes and plead the insanity defense. Uh, Even more significant is when the insanity defense is asserted or invoked by someone who is in a position of power and influence, and the victim is vulnerable. It's harder to um, raise the defense successfully in such a situation. And I want to make those points clear as we go along. The other important thing about the insanity defense, apart from the relationship of power and influence, is what I call the gender as an influencer.
Mm.
Gender as an influencer. So I intend to spend much of my time tonight talking about gender as an influencer in the insanity defense, because that's when we get into domestic violence, right? But we want to establish a few important scientific facts based upon research about the insanity defense. Before we get to gender as an influencer, the other thing that we need to understand, or we should take note of, is that attitude towards the insanity defense is largely driven by public attitude towards mental illness.
Repeat that once again.
The public attitude towards the insanity defense is largely driven, significantly driven, by the attitude of society towards mental illness as a whole. And this is also going to be another important aspect of what I would discuss this evening, because when the insanity defense is not properly raised and seems to have been abused, it sets back work that people who seek to genuinely have the insanity defense recognized in proper circumstances, and for the impact of mental health on crime and society to be taken more seriously, it results in setback, because the more people become skeptical and the more people begin to dismiss mental health as a contributor to violence in society. These are important points to note. And there is a general attitude by society to not treat mental illness as something that one should be sympathetic. And because the manifestation of mental illness is usually violence, and very often it is violence towards strangers. And not only that, the researchers have found that the media have played a significant role in creating this false perception of mental illness, as usually the mental illness is often portrayed as something that significantly manifested in violence towards others. And researchers have found that this basically is not a proper portrayal of mental illness, but it is in fact one of the significant things that the media does. And they've looked at even the portrayal of mental illness in movies and found about 80% of characters portraying mental illness are usually characters portraying violence as the manifestation of that illness. And therefore, there is a stigmatization, a criminalization and a stigmatization of the illness itself, rather than view it as a form of illness like any other illness that requires proper treatment and intervention and sympathy from society, right? Now, there's also researchers have found that there is a refusal to accept real facts about the insanity defense, and there are lots of myths about the insanity defense itself. And some of these myths are fueled by uh, portrayals of mental illness and portrayals of the insanity defense and all of that. And many of these myths are completely false. Like lots of people believe that the insanity defense or not guilty by reason of insanity means that a person completely escapes penalty for the action and all of that kind of thing. And we come to the big one, gender as an influencer. So before I get to gender as an influencer, let me say a few more things about myths. Lots of people believe, this is what research has found, that the mere invoking of an insanity defense usually results in a high level of success. But the actual fact is that few people succeed with the insanity defense. There is also the myth that the insanity defense, invoking it, results in a lighter penalty. All of these things fuel the attitude towards the defense. But researchers have found that persons who plead the insanity defense usually end up with higher penalty, stiffer penalty, greater penalty for the same offenses committed by others who did not plead the insanity defense. But there are these perceptions. And so researchers over the years have decided to dig into what really are the facts of the insanity defense. All right. Now, gender as an influencer.
Before you
Now,
go there, Vivian, what are some of the factors that causes very few people to succeed with the insanity defense?
well, it goes back to the things I was listing
Yeah, okay.
up there, right? That we live in a society. Remember, guilt is determined by juries, and juries bring to a trial their prejudices,
Mm-hmm.
and a person's knowledge structure could be based by, on that person's own personal prejudices, right, and perceptions. And so when you look at how perceptions are formed, if you have myths and all of these things driving perceptions, you're going to find jurors who sit to determine whether or not a person is guilty by reason of insanity, fixed in their perception of mental illness and attitude towards the insanity defense. And these are some of the things that give rise to very low success rate with respect to the insanity defense.
Mm-hmm.
You also have to remember that lots of times crimes committed by persons who plead the insanity defense are some of the most horrible crimes.
Mm-hmm.
They're crimes that sometimes are so horrible that it's you don't even simply telling someone about it. People don't really, they would say, spare me the details. And imagine jurors having to sit
Mm-hmm.
and listen to a person and look at the person who commits such a crime and then say, we vote not guilty by reason of insanity, right? And consider the fact that I said that we live in a society driven by a desire for punitive measures. When you add all of these things up, the insanity defense is an uphill battle, and this is across the board. Now, gender as an influencer, and this takes us to the, if you wish to say, the case study. Amazingly, gender is is one of the most significant factor in the success or failure of the insanity defense.
Hmm.
Because the researchers have found that the success rate already being very low, that it is women who are more likely to vote in favor of the insanity defense. Because it is
Oh.
women who tend to be more sympathetic in
Hmm.
their outlook towards insanity rather than men.
Whoa.
So now here's an important point to note. So in every criminal trial, particularly a trial where the insanity defense is pleaded, one of the important things why you do these kinds of research is because jury selection becomes a very important process. So when you're pleading the insanity defense, you're working hard to get women on the jury. If you see
Oh.
where I am beginning to go with this. So,
Okay.
because women are the ones who are likely to be sympathetic to the insanity defense. Men are less sympathetic when the insanity defense is raised. That's point number one when we consider gender as a factor. Now, here is the other very important factor as it relates to gender, that it is women who make up the bulk of defendants who plead the insanity defense that succeed. So when you take the already low rate of success for the insanity defense, you have to take a greater portion of that, set it aside for women, and then the success rate for men is exceedingly low. Here's what the researchers have found with respect to women. Very often, while they succeed with the insanity defense, one, most of the crimes that women commit when the insanity defense are pleaded are crimes against family members, domestic related crimes, which is why domestic violence and the insanity defense I find to be a very important topic for discussion. Very often you would find that when women plead the insanity defense successfully, there are unusual crimes. A woman having taken the lives of her newborn baby, her own kids, or a woman becoming very violent against a partner that was abusive.
Mm-hmm.
And what usually is found in those situations is one, the woman doesn't have a prior history of violence,
Mm-hmm.
a prior criminal history. And even when uh, sentences are served and the woman is reintegrated into society, you usually have a low level of repeat criminal conduct by women. And so when you have, for instance, a jury looking at a woman who commits an unusual crime, jurors find it hard to believe that a woman, in understanding the extent to which women are um, the foundation of homes, people tend to sit up and sit at the edge of their seat. What would have caused, and begin to really think, what would have caused a woman to react in this way to her own family? The opposite of men. Most men who plead the insanity defense, they commit crimes to strangers, crimes against strangers. It is therefore harder for one to um, gain the sympathy of a jury where your crime, this horrible crime, is a crime committed against a stranger. The other important thing about gender, domestic violence, and the insanity defense is women are often viewed as more vulnerable within the family setting. And there is a concept in law called the slow burn effect, where if you expose a person to traumatic experiences, uh, dehumanizing experiences, emotional abuse, other forms of abuse, that it creates a slow burn that ultimately leads sometimes to a person, what you call the straw that broke the camel's back, somebody flipping in an instant. And very often, when women the some level of diminished capacity or insanity, even in the sentencing, even if they don't succeed, that kind of consideration would lead to lighter sentences because it is taken into consideration that this woman was going through this kind of abuse over and over and over, and until she eventually closes her eyes and begin to, like, one would rationalize a woman shooting an abusive partner 14 times. Now put yourself in a jury rationalizing a man raising the same defense, having shot his female partner 14 times. You see the difficulty you have here, right? And that is one reason we talk about, and researchers have found, that relationships of power, or the relationship of power and influence and vulnerability, play in one's consideration of whether the insanity defense is an appropriate defense that one should pursue. Because at the end of the day, the researchers have shown that it leads to harsher penalties when you fail. One of the reasons being that prosecutors look out for, and juries look out for, what you call faking it. Many people commit a crime and then you begin to fake it, to pretend to be inflicted by some kind of mental illness. And very often it is viewed as not owning up to your actions. And you get hit harder when you try to fake it rather than simply, own up to your actions there. And when you consider the case of the military officer, very high-ranking military officer in Guyana, this is not a defendant who is vulnerable or who fits the vulnerability profile that a juror would be sympathetic, or a jury would be sympathetic with, right? So also, the victim in this case is falls within the vulnerable category. And so it's an important shift. I don't know if it was a callous, thoughtless thing, but it strikes me for a man in a domestic violence setting to even begin given this kind of research, to contemplate insanity as any form of insanity or even slow-born effect as a way out. When you look at a particular case like this, what you would see, a man who carries a weapon, a woman who is not armed. These are images of power and influence. These are not images that would cause one to say or to feel very sympathetic towards that person. Like, here is a vulnerable person, right? So that is a significant shift for, and I would say it's a heavy lift and a very difficult climb to try to sit before a jury and say, I had some kind of mental illness that caused me to respond in this way to a vulnerable person viewed generally as vulnerable. So, go ahead.
I have a question. Do you think, I mean, yes, you quoted the studies, but does that apply to Guyana?
Well, it's an important question, and I thought that you would ask it. Because interestingly, lots of times these kinds of studies ought to be done in Guyana to see what happens, how juries respond. Like here in the United States and other parts of the world, when you lose a case or whether you win a case, you sometimes poll jurors. You want to talk with jurors after. What took you in this other direction? And there are researchers who go to these studies. There is there's a whole host of psychology and all of that is involved. And when you begin to prepare a defense team, you call experts in. You don't just say we are lawyers. You call experts in, and they would say this is what the data the data says with respect to X, Y, or Z. And even before you get to the point of strategizing, you want to know this. But what is important, and the reason why I pointed it out, is that researchers were amazed when they looked at studies in the United States and Canada, North America, and then they looked at what other researchers were doing in places like Japan, and they found that the results were identical. So they so you look at places where there were significant cultural differences, but the data, the findings, the analysis is coming up the same. So, and when you look at it logically as to what is taking place, you recognize that Guyana and these other places would seem to fit into this kind of profile. It's hard to see us as an anomaly to what researchers are finding, right? So I think the researches are relevant, but I've always been stressing that we need to have a research-oriented society, and we need to stop. We need to set aside the attitude that social science researchers are not significant in a significant component to any attempt to solve various problems in society, whether it's crime, whether it's suicide, whether it's anything. Because we tend to think of social scientists as, you guys just go and deal with the homeless or something, right? And don't recognize that they play an important role. Lawyers hire social science researchers, behavioral science researchers as part of their team when you don't see them because they can't appear, in the well. But they're part of the team. They're part of the team from day one when you begin to decide on strategy and defenses and all of that. Now let's look at so I think without research, unless there's some research to that points differently, I would think it's applicable because it's also rational, it's logical that jurors would find it difficult. And so if you begin to ask what type of jury would the defense seek to assemble in a case like this, that would be sympathetic. And then when you also consider the specific time that this is happening, where domestic violence is a major issue in society and something that is likely to become more dominant in media coverage and in society generally by activists and all of that. It's hard to not consider this as a factor.
Mm-hmm.
If there's another comment or question, I'd be happy to address it. If not, I'd move on to another point that I wish to raise.
I think Tracy had a question. Mr. Williams, can you say the number of cases tried successfully in Guyana based on insanity defense?
Well, I wouldn't attempt because Guyana is not a jurisdiction that you have a lot of data available, and I'm not on the ground in Guyana. But if there were data available, my orientation is to gather it wherever I am, and I believe that we need to get to that point where we need to have a data-oriented society, and because it facilitates research. If Sharmin Prince decides that she wants to take a look at mental illness in Guyana because she has a charity or she has some kind of program that she thinks could assist persons suffering from mental illness, you should be able to do research very quickly. You shouldn't have to struggle. You shouldn't have to say, well, I have to fly a team all the way to Guyana and we have to spend 6 months before we get 2 pages of data. So there needs to be the collection of data, and that needs to be available. And it would be interesting to see what the data with respect to the insanity defense in Guyana actually tells us. The other point that I want to make is that when we look at what exactly happened in this case. So the factual reports that you get is that you had somebody who commits serious crime with a service weapon, and then I don't know if the defense give thought to this when they well, we also have to take a pause and give the defense some space. But it's interesting because insanity basically is relevant at the time of the commission of the act. It's not whether you become insane after you committed the act. Anyone who commits a serious act and whose future is on the line, or who finds himself or herself facing incarceration for life or a death penalty, would become extraordinarily stressed out. And you could have an onset of mental illness subsequent to the act. And it is not even whether or not a person was mentally ill before the act. Of course, some mental illness before the act creates at least some kind of benchmark that you could say, well, we know that this person had some mental illness prior to the act. But the important question is, what was the state of mind of the defendant at the instant of the act? So here's what we know: that the defendant immediately after the act surrendered himself to the nearest police station and turned the alleged murder weapon to the police. And that basically tells you that you have a defendant who was aware of the nature and consequences of his act. And the question of insanity is always, were you so inflicted by mental illness that you could not recognize and were not aware of the nature and consequences of your action at that instant?
I totally agree with you, Vivian. My concern is I have worked for the past, maybe let's say 18 years with people that have mental diagnoses. Now here is an aide to the chief of staff who worked the day prior, committed this heinous crime, got on the phone. It's alleged that he called his ex-wife, made arrangement, come and get this, move into the house, made all these arrangements. Now, how can someone who had a psychotic episode, that's what we're going to say, who had a psychotic episode that caused him to commit the crime, but was able to get out and make salient decisions?
Well, these are important things with respect to, and it's always important not to try a case in the media, but of course, the discussion on the insanity defense and mental health is an important discussion that should go on. In assessing the availability of the insanity defense to a defendant, the important period that a jury would consider would be the period leading up to the event. What was the defendant doing the day before? Was the defendant employed? Was the defendant at work the day prior? Where was the defendant on the night prior? What was his state of health on the night prior? Mm-hmm. And not just the night, but the weeks leading up. Because a person absent some sudden traumatic event or some use of some substance, a person doesn't get a sudden seizure of mental illness. Is not suddenly seized with mental illness. You could begin to look for signs of withdrawal, signs of unusual behavior, which is what a jury and a prosecutor would be displaying. So when you begin to retrace what happened in the weeks, months leading up to the incident, particularly the last few hours leading up to the incident, that is where I think an assessment of any kind of mental illness would become significantly relevant. What a defendant does after the incident is not so much important as to what was his state of mind and his behavior leading up to the incident, because it is well established that a person who is faced with the death penalty or a complete change in your life, incarceration, could become so stressed, so emotional that the person could genuinely suffer anxiety and fall into any kind of mild or extreme mental illness. So even
No,
if someone
situational. We could call it. They call it like a situational depression.
right,
Yeah.
that so even if you find one examines a defendant subsequent to the act and finds that he has gotten into uh, that mental state, it doesn't mean that the person was not guilty or didn't know the nature and consequences of his actions at the time of the commission of the particular act. But it's important, and not only to have these discussions, but to look at when things happen, what is the response of the society, and what are changes that are necessary. And I started out by looking at relationships of power and influence and how these things are assessed. And one of the significant things about this case is the fact that you have um, servicemen, men in the military or some form of military service, whether it's the police or the joint services, who carry weapons, who exist in domestic relationships with families, neighbors, and part of the community, but they carry weapons. And when you have a situation like that, I think it is important that they their mental state be properly assessed, and that the slightest indication that there was some issues, mere issues, that there is the appropriate intervention that one may result in the person either placed on leave so that you could get the adequate treatment,
Mm-hmm.
or that the authorities take the necessary steps for a proper assessment of the person who's carrying weapons. And this has nothing to do with, and this goes beyond violence within the home or domestic violence. So it must have been an extraordinary statement, and one would have expected that the media would have been camping out at Ayangana immediately, a few minutes after, when the defense attorney makes a statement in court, which means it ought to be truthful, that the defendant was receiving some form of psychiatric treatment for 2 years. How do you have a professional treating a man who is the left arm and right shoulder of the chief of staff, who carries a weapon so close to the chief of staff of the Guyana Defense Force, which means his proximity to the president of Guyana
Mm-hmm.
is so close, to be receiving such a treatment and continue to be in such a service for 3 years? If that statement is true, that's an outrage. That's an outrage. And I mean, a real press corps would have been asking the chief of staff, were you aware of this? Is there a procedure by which you would have been aware of this? Because it goes beyond. I mean, this is someone who has access to the president. And if you're saying that this person had or has been having a mental illness for as long as 2 years, what procedures are in place for this form of assessment and for this form of reporting? And you also have the issue of what would be the responsibility of the medical professional, privacy aside, in a situation like this. And this would also play out in a defense, because if you are the doctor, psychiatrist, whatever, treating such a person, even if you don't take the extraordinary step to report this to the um, superiors of this, the employer of this person, in light of the security issues. One would think that there would have been a recommendation by that professional to the serviceman that he should take leave, treat his condition until it is his condition is reach a satisfactory level before resuming duties, before continuing to carry a firearm, before continuing to serve in that position. And the question is, did the professional provide that advice? And if the professional did provide that advice to the serviceman and he refused, for instance, you would advise him that you need to discuss this with your boss, with the chief of staff, with the human resource. And if his the medical professional did make such a recommendation, and the serviceman refused to disclose this to the authorities in the army, it becomes exceedingly difficult for him to gain sympathy in invoking and succeeding with the insanity defense. Because one of the things you look at is whether or not the defendant has created or contributed to the circumstances that led to the criminal act. And this would be grossly irresponsible conduct from the defendant. If the defendant is given that kind of advice and did nothing about it, continue to hide his state so that he could continue to carry a firearm and continue to be a danger. The other important thing that you begin to hear in coming out in the press is some people are saying, oh, we know that he engaged in prior acts of abuse. We know that this person had engaged in prior acts that were very troubling. And the question is, and I think I saw one comment by a social activist, someone involved in this kind of work. And the question is, if you know that a close friend, acquaintance, associate, colleague is engaging in domestic violence and that person carries a weapon, I think that the society, members of the society, should begin to take some responsibility that you should write to this person's boss and say, you have a serviceman who's my neighbor, and I know him, that this particular person is engaging in domestic violence, so that the military would have a report and they could investigate. And if you have a friend who, or you're a social activist, or you're involved in mental health or any kind of social work, and you know someone who's in a position of authority, carrying a weapon, but you know this person to be a person that have a troubled mind, what is your responsibility? I think initially to the individual is say, look, I know you have a temper, I know what's going on, maybe you should talk with your employer, get this kind of help, and then you see what the person does. And if the person is not taking proper steps by which you could be guaranteed that the society and that the home is secured, then maybe you could write, even if it's an anonymous letter, to the superiors so that they could investigate. So I think it's troubling that you're hearing all of these statements of what happened over the years, and yet this person was allowed to have a service weapon. Because if the person probably didn't have a weapon, it would have done that person more good. Because in that moment of losing it, a weapon would not have been there for the person to take it to that level. So it would have helped the victim, and it would have also helped the person who engaged in this act. So there is a collective response that society should be engaging in. Can't just simply sit back and say and wait for when something like this occur to then say, oh, I knew this, I knew this, I knew that, right? Concrete steps must be taken to ensure that it doesn't get to this level.
But because of the culture and the practices within the Guyanese communities, and if a neighbor had written a letter to the chief of staff in this case to say that I know that your aide is a known abuser, nothing would have been done.
Well, when we have a duty in society, performing our duty should not be dependent on whether or not the result that we desire from the performance of our duty would be obtained. Failure to perform that duty, failing to perform that duty, we can then sit back after the fact and say, I knew nothing would have been done. The point is, if a letter was sent, maybe there would have been some questions asked. Maybe there might have been some discussions taking place. Maybe this person who committed this act would have been aware that his superiors are aware of his conduct and that he is under some kind of review. Mm-hmm. Maybe if the authorities had received one letter, two letters, three letters, a few phone calls, that maybe they might have done nothing after they received the first two, the first three, but they subsequently would. And you have to remember that advances in media have now, or communication technology, have made it difficult for people to not respond to complaints. Because if someone writes the chief of staff and the chief of staff does nothing, if someone writes any member of any body and the person does nothing, that person could put the letter up on social media. And if something happens, the person could publish it. And you are placed in a position where it's impossible for you to deny receiving it. And then you are placed in a position where you didn't act. So I think in the past, the authorities might have not taken complaints seriously, but I think people are starting to realize that when you receive complaints, you just can't not do anything. So I don't think that is an excuse for people not coming forward and saying this is happening. And if you have an isolated incident, it might be an isolated incident. But when people are saying, "Oh, I know that this has been the temperament for ages, for years," you can't sit back and say, "I have known that this was taking place year after year after year, but I didn't say anything." And when you consider the fact that this person carries a service weapon, you can't have a hot head carrying a service weapon.
I agree. Totally
right?
agree.
And you also have to look at it that this is a person that was within a close shot or had access to the president. Let me say had access to the president and the chief of staff. These are very important people in our society. And one of the major cases, insanity defense cases, is in the United States, which everyone would be aware of, is the John Hinckley case. The John Hinckley case with President of the United States, Reagan, was one of the cases that had created a firestorm in the United States. It After Hinckley succeeded with the insanity defense, I think within 2 years, 34 states had changed had rewritten their statute with respect to the insanity defense. And it even resulted in sweeping congressional changes to the insanity defense in the United States. So, you know, people acting in crazy ways could affect even the head of state, in a country. And I think that when you have people who get clearance to be to be within a shot or to carry a weapon in proximity to the chief of staff of the Guyana Defense Force or the president of Guyana by virtue of being close to the chief of staff, that the vetting process is not the regular vetting process. It has to be a different level of scrutiny that is involved. And I think it would have been hard for the chief of staff not to do anything if he receives, official complaint in this regard, right? And not only should there be a one-time vetting process, but there need to be a continuous vetting process. A continuous vetting process so that if there are changes in the status, it could be detected and some kind of action could be taken to ensure that you don't have things like these happening.
Agreed. In 2015, there were two cases of insanity defense. The first was Ryan Bob Semple, a man accused of sodomizing and killing a 9-year-old. And then Al Muhammad, who was accused of killing his father with maybe a 4x4. And both of them had insanity pleas. However, there were no follow-ups on Bob Semple, but in 2017, it took 2 years for them to get a psych eval from Dr. Harry for Al Muhammad. But after 2 years, that insanity plea was overturned and he was deemed fit to stand trial.
Well, okay, so the insanity defense has several stages. One, you make an attempt, you try to set the groundwork to invoke it as a defense. And at least here in the United States, judges will even make a ruling as to whether or not you could proceed with that as a defense. So every jurisdiction, it is different. In some states in the United States, the insanity defense is not even accepted. You can't even make that as a plea. Mental illness is just used as a mitigating factor in sentencing. So the first thing that happens is that there's an evaluation of any defendant, whether or not the insanity defense is part of the defense strategy, to determine whether or not the person is fit to stand trial. Being fit to stand trial is not the same as the insanity defense itself, because being fit to stand trial examines the mental state of a defendant after the act. It looks at the state of the defendant during the trial process. If the defendant is deemed at that point not to be fit to stand trial, it doesn't mean that you never get tried. It means that you then get treatment until your mental state has improved to the point where you could stand trial. So your trial may be delayed, but not being fit to stand trial doesn't mean that you would not be tried. So that's one thing. But if the evaluation comes back and says that you are fit to stand trial, then you may proceed. So you could have someone being deemed not fit to stand trial, even though that person is not raising the insanity defense.
Okay.
Because in the interest of justice, a defendant must be able to participate in his defense. And if the defendant doesn't have the state of mind to understand what is happening at his own trial, you wouldn't have proper justice in a situation like that. So the evaluation as to fitness to stand trial is not the same to say that a person is found not guilty by reason of insanity.
Okay. Okay.
In this particular case, the action of the defendant immediately after the act, or the alleged action of the defendant immediately after the act, I think is very, very significant, because that or those actions give a clear indication of the defendant's state of mind as to his awareness of the nature of his actions at that time. And that is the period of evaluation with respect to the insanity defense.
Okay.
It is important too, whenever you have a high profile case, which usually sets back attempts to have mental illness be given the importance it deserves in trials, in the assessment of criminal conduct. Whenever you have a prominent person or a person in a position of power faking it or seeking to hide behind the insanity defense without justification, that creates significant problems for persons who seek to legitimately and properly invoke insanity as a defense.
Okay.
And this is one such case where you have a high profile person in a position of power, a victim who falls within the vulnerable category, and significant media and public attention and interest in the case. So if you have a situation whereby insanity is not properly invoked, it could result in some impact on public perception and public attitude towards the defense generally.
Wow. There's a lot to learn about the legal aspect of the insanity defense, because you'll think that by being knowledgeable and have an understanding of mental illness, you have an idea, but it's totally different. The layers and the levels and what could be accepted. I mean, we'll just have to sit and see what becomes of this case.
Yeah, mental illness is not an excuse to commit crimes, and that is the attitude of juries.
Mm-hmm.
It's the general attitude of the public. The question is, the research is out there that even people who are diagnosed as crazy or having some mental illness, that they're not 24/7 crazy, that there are moments that they know what they're doing, and so the real question is, what was the state of mind? Did you really know what you were doing at that particular time? And it's the reason why lots of times when you hear people raise mental insanity as a defense, they would say things, the person was seeing things, like they took a particular person to be a demon. They thought that they had a moral duty and a moral obligation to kill this person, or that they felt like they were under attack, that they felt that this person was here to cause harm, and this was their response. So that's a kind of situation where you're saying this person really didn't have that state of mind where they were able to recognize it's a break from reality, right? So you have to establish a break from reality in that specific moment that that crime is committed.
Just let me look to see if we have any questions. Tracy had a lot of questions or comments, but I'll look to see if there were any questions. Sharon. Someone said as a defense lawyer, you have to use every available tool that can be used to help your client. We in the public duty may or may not approve it, but it's still the lawyer call to explore all avenues. I guess she is just commenting about the defense lawyer decision.
Of course. So a defense lawyer's duty is to raise every possible defense. But usually when you raise the defense, and quite frankly, a defense has not necessarily been raised at this point in time. So a defense lawyer may keep his or her options open. And depending on the evidence presented, that you raise every defense, insanity being one defense. Some people raise insanity to make sure that their client is not sentenced to death, or to avoid the death penalty, sometimes to avoid a life imprisonment. But the point that I make is that one has to remember in raising the defense that where the defense is unsuccessful, very often you have penalty, or where the defense is not just unsuccessful, but where it's invoking, it seems to be an abuse or seems to be baseless, that the penalty that ultimately comes down, what the data is showing, is more severe than if you had not raised it. And part of the reasoning behind that is judges and juries want to see that you are showing some level of acceptance of what you did. And by trying to pass it off, your conduct off, to a state of mind that was not existing, a non-existent state of mind, by trying to excuse it in that way, that it comes back to affect you, because you get a harsher penalty. And so a defense lawyer who is invoking insanity as a defense would consider all of this before you get to that point. And it is not to say that the defense in this case has in fact invoked insanity as a defense. They seem to be lining it up as a possible defense. I find that to be a little bit not consistent with the facts that are coming out with respect to the case at this particular time. There are other defenses which we don't see that are being lined up, but there is a particular other defense that I thought might have been would have been more that it would have been leaning into that defense more. And that is a defense you see very often raised by servicemen, which is accident. So we don't see that accident has been played out as a defense. And an accident, you know that an accident with a weapon, particularly when you consider 14 rounds being fired off, a serviceman may claim, the weapon jammed.
Right.
Something happened beyond the person's control to stop the weapon from firing. And that could be a serious defense for a person who knows weapons and who retains the weapon in his possession for a period of time, because you could have a defendant, a person who commits such an act, has some time to tamper with the weapon even before the weapon is handed over. But here you have a weapon already handed over to the police. We don't know whether or not it was tampered with within the short space of time. Military servicemen are trained to do all sorts of things with weapons. So if someone had claimed that there was a problem with the weapon and there was an accident, really you would have to line up a number of witnesses to contradict that and the examination of the weapon. But that's not a defense that as of this point in time, seems to have been lined up. And we know that the defendant in this case took very sane acts, and the actions are the actions of a person who recall his training, his requirement under his training, and the law, and they didn't seem to be to reflect a break in reality at that particular instance that the action was occurred. So when you consider all of that, I find insanity as a defense to be more than an uphill climb.
Before you go, Tracy asked a question. She asked if the prosecutor can stand up to the defense of the defense lawyer. And today I was asking a few questions in preparation of this show about the prosecutors. In Guyana, they are not lawyers, right? They don't have the training like lawyers. So that questions, Tracy, we'll have to have another show to answer that question.
But, the question of prosecution, one of the things about high profile cases like this, particularly at the time where domestic violence is on the radar, through public pressure, I think the state would be under pressure to ensure that the prosecution of a case like this is at the required level.
Okay.
Because you have, failing to do that, the state could take a lot of pressure for not doing enough to give real meaning to victims, to any talk that cares about domestic violence. This is a high profile case, and in a high profile case, the state is under pressure to ensure that it is assigned to a competent team of prosecutors, and not only that it is assigned to a team of competent prosecutors, but all necessary proper steps are taken for a transparent and proper prosecution. So I don't think that it's a question that is beyond any kind of response. I think that you really couldn't take any ordinary person and have that person prosecute this case. And particularly if, and we don't know yet, if insanity were to become an issue in the case, that would involve a lot of experts. It would involve looking at a lot of records. I know here in the United States that they would go back and see whether or not the defendant has a way of manipulating. They would go back and subpoena things like your entire social media, which includes emails, WhatsApp, Facebook, and that includes all of your behind the scene messages. And so they have a complete profile of you, the things you did, how you behave, what you said, and all of that. So the prosecution could do that if there's an attempt to hide behind an insanity defense. And I think it would be very easy to establish the stability of mind of the defendant, because this is not a defendant who is a farmer, who has no electronic profile, who has no public profile. It's easy to recreate the public profile of this person. Few hours leading up, days leading up, months leading up, it's easy to retrace that. And so the defense would be under extraordinary challenge to prove that this person suddenly had a break from reality, and not only a sudden break from reality, but that the person acted responsibly to avoid such a break in reality and to avoid the particular act. And I think that those are important issues that they're going to have a big challenge. And you have to remember that when you plead insanity, you're more or less admitting you did the act. So if you don't, so if you fail to prove that you had a break with reality, then you're left with you're admitting you did this thing. You're admitting that you did all of these things, right? Which is the reason why very often in a situation like that, one may plead, and one may claim as a defense accident. Its accident is that even if you prove that the shots were fired and they were fired from the weapon, when you think about the rational action of the defendant after acting professionally as a serviceman, lodging the weapon, then the real question becomes for an expert: could this weapon have been malfunctioned at a particular time? And all of that, and that would be an intricate matter, and that I think would be a defense that would carry some leverage, because it's hard for a bystander to make, and you really have to have credible witnesses who would be there at the time of the trial to describe what really happened, right? But the insanity defense, I think that's a little stretch.
If you had one encouragement advice for the defense lawyer and the state, what would that be?
Well, from the point of view of a prosecutor, I would say that the prosecution should put everything, all of its resources and its best prosecutors. The state should find the best prosecutor for a case like this, because there is a need for public confidence in the judicial system. There is a need for persons in power, particularly who use instruments of the state to carry out domestic violence, to recognize that such actions will not be tolerated by the state, and to recognize as those who oppose insanity defense claim that any insanity or any defense is not, some kind of flimsy excuse to find a hole in the law or in the judicial process to escape penalty. And I think that recreating the state of mind and the actions and inactions of the defendant in the period leading up to the incident would be critical. And the preservation of the weapon and statements that the defendant might have made to ensure a defense against an accident, because I think accident could be uh, a defense that could prop up and could have some leverage, because you have a weapon, a person could claim they held it, and what happened with it, holding it, and we see it in many instances. Of course, when you look at the popular Oscar Pistorius case in South Africa, it was accident that he relied on. I accidentally shot this person, right? He didn't claim insanity. He didn't, it was accident. And um, he went to the point where um, he was able to some extent, get a very um, light penalty initially with respect using the accident as a defense. So his whole defense was based upon I shot this person by accident. So the prosecution would want to be able to, would need to begin to do work to ensure to close those holes. From a defense standpoint, a defense attorney has got to do what he's got to do. The defense attorney, if he has any kind of public interest on his mind, can't take the case. So the defense, from a defense standpoint, I think the defense, before it begins to telegraph and before it begins to make statements to the court in the media, because Guyana is a small country, a jury will see it. Usually, when you make a statement in court, the lawyer makes a statement that is not admitted into evidence. But everybody in a high-profile case, the jury pool is likely to see the statements that you make. So the defense would want to be clear as to what are the evidence here. Who are the eyewitnesses? What people know? What is basically bare hearsay from what are really factual? And then you begin to craft what are the proper available defenses. Because if it turns out that many people were, I was driving in a car that was several blocks away, you're not a proper witness to whether or not this was an accident. Because 14 rounds, 14 shots, it's a few seconds, right? So the defense really wants to know all of this before it begins to take positions in terms of sanity, insanity. You have to look at the actions of the defendant and look at the defense itself and understand. And I would say that they need to understand who would be the jury. You have to think, when you think of this defense, who are we playing this defense to, right? And would they buy it? Why should they buy it? What is the likelihood that they would buy it? How would it play with this particular jury? And in this case, I could hardly see the defense saying that, look, we're going for a jury pool of women, right? And the insanity defense, from research, it doesn't play well with men. And usually when a male is involved, its likelihood of success is greater if the male violence is a violence to a stranger, not violence in a domestic setting. So the defense team must understand that, and it needs to have a competent team of experts to look at all of these kinds of things before making public statements and before going out there and taking positions.
Well, I want to thank you for sharing your expertise with us. Please don't use the word crazy anymore. Because in the social service or human services, when we hear that term, it offends us.
So I'll start redacting that word from all of from my vocabulary and any documentation that I may have it. You know. So
Thank you. Thank you. But thank you, and I know you have to be back to follow up. So because we have to follow up on this case. It's being tried in the media, and so I want to thank you because this was important. I learned a whole lot. That's why I'm silent about the legal aspect of insanity pleas or defense. Thank you so much, Attorney Vivian Williams. Thanks to the viewers. Thanks to those of you that commented. If you didn't share it, please share the live. And you don't want to miss next week's show. Next week, I have my um, sister veteran, Melinda Smalls from California, and we will talk about trauma and moral injury and PTSD and how we overcame those our moral injury, PTSD, and traumatic experiences. So you don't want to miss that. 6 o'clock next Sunday here on Facebook Live. I want to thank you for your continued support and have a blessed week ahead. Good evening. See you next Sunday. Thank you for joining.
thank you,
Thank you so
Sharmin.
much.
It was a pleasure.